Good afternoon, everyone. I'm Richard Meeran. I'm the head of the International Department at Leigh. Thank you for joining us at the first of our two webinars on the subject of holding the powerful to account, European perspectives on strategic litigation. In today's event, we're going to look at litigation against multinational corporations in the courts of European countries, and these are cases in which it has been sought to hold multinationals to account legally for human rights abuses which have occurred in developing countries. And just by background, the object of these cases is to hold multinational companies, particularly parent companies, to account legally in their home state courts. Now, that may be for harm that has arisen from the operations of subsidiaries or within their supply chains. And the goal then is to provide a remedy for victims and also to act as a deterrent against future abuses. Now, these cases raise challenges at various levels, legally with regard to particularly the corporate veil and issues around jurisdiction, procedurally in terms of access to information, internal corporate information especially, which is needed to prove a case, and issues like protection of witnesses. And practical challenges too, particularly around issues of funding for legal representation and retention of experts who are often required for some of these cases. Now, the law has been developing in this area for the past 25 years, really in parallel with developments that have occurred in the field of business and human rights generally. And if one looks at the central feature of the UNGPs, the UN Guiding Principles on Business and Human Rights, there is a striking similarity between the principle of human rights due diligence and the parent company duty of care, which has been alleged in many of the legal cases, which indicates not just things happening in parallel, but a convergence of these two areas. In Europe, there have been cases pursued in the UK, France, Netherlands, and Germany, and our four speakers today have been at the forefront of recent cases in these countries. And what they're going to do by reference to the cases that they have been involved in is to share some of their insights into their own legal systems, the types of cases that are feasible, key benefits and disadvantages of their systems, and how they decide what cases they should take on. Now, I'm sure the discussion will elicit some interesting and important similarities and differences in the legal systems and the remedies that are accordingly available. Now, rather than asking them to discuss everything in one go, I thought it would be better to break down the discussion into three questions that each of them will address for a few minutes, and then at the end of each question we will have a 10-minute panel discussion which will include comments and questions from the people who are listening. So if you want to make a comment, there is a feature on the screen that you will see, a Q&A feature at the bottom of the screen, and so you can post your comments and queries there, and those will be emailed through to me, and I can make sure that at least some of them are answered when we have our little discussions at the end of each question. Now, if all goes to plan, that should take us through to about 5:30, and we're not necessarily stuck to that deadline, but we'll try our best to keep to it. The first question, which you should have up on the screen, or should be coming up on the screen, that I'm going to ask our speakers to discuss, is what areas of human rights abuses arising from multinational operations overseas have been or could realistically be litigated successfully in your country. And I think we will start the ball rolling with my partner, Dan Leader, who is in the international department with me. Dan has been at the forefront of some groundbreaking cases over recent years. Many of you will have heard about the Mau Mau case. That was a case that was done for thousands of victims of the Mau Mau rebellion in Kenya, against the British government. More in the context of today's seminar, though, are the big environmental tort cases that he's been involved in, especially against Vedanta and Shell in respect of its operations in Nigeria, cases both of which are so critical in terms of development of the law on parent company liability. So Dan, if I can just hand over to you to discuss that first question. And just as a warning to everyone, I think I've mentioned it, there's going to be a buzzing sound that, that is made at the end of your allotted time.
Thank you, Richard, and good afternoon, everyone. It's a great pleasure to be part of this seminar with some really expert people from across the continent. Over the past 25 years, a string of civil claims have been successfully brought in the UK against parent companies, as Richard has mentioned, for human rights and environmental abuses committed by their foreign subsidiaries. The claims, it's important to understand, are brought by individuals or communities for damages, and also importantly, in some cases, they can seek injunctive relief for environmental damage. They do this by using common garden tort law, generally applying the legal framework of the country where the harms have arisen. Civil claims of this sort must be brought by the victims. They cannot be brought by public interest groups, unlike, as I understand it, the system in many countries in Europe. Now, these cases use the principle that Richard has alluded to, the principle of parent company liability, which, as I understand it, was his brainchild some 25 years ago. It's important to understand that parent company liability is emphatically not an attempt to pierce the corporate veil. What it is, in essence, is when a parent company exercises de facto control, direction, or oversight over a foreign subsidiary in a manner which is directly related to the harm that has been committed, then it too can be held legally liable. So if I can just illustrate that with an example, if a parent company is responsible for an environmental policy framework of a subsidiary, which is flawed and results in systemic pollution of communities in Nigeria, for example, that can lead to legal liability. Now, over the past 25 years, the case law on parent company liability has become quite extensive, culminating last year in the landmark judgment of the Supreme Court in the case of Vedanta, which was a case brought by two of my other partners, Martin Day and Ollie Holland. And it's such an important judgment, I just want to finish with three brief points about that judgment which the Supreme Court made. Firstly, the Supreme Court said there's nothing novel or controversial about parent company liability. It's not an unprecedented extension of the scope of tort law. Secondly, they said that the scope of parent company liability can be very broad. It shouldn't be just considered through the prism of operational control, it can be considered in terms of intervention more broadly construed, such as supervision or advice to the subsidiary, not just control. Thirdly, the Supreme Court was clear that the global policy framework of a multinational company, if it is flawed, can also give rise to legal liability. And that is a principle that multinational companies have been fighting tooth and nail in recent years through the courts, happily now unsuccessfully. And then finally this, which for us is an extremely important innovation in our understanding of parent company liability. The Supreme Court said that if a corporation holds itself out as exercising a degree of supervision and control of its subsidiaries but fails to do so, its mere failure can give rise to parent company liability. So in essence, what that means is the Supreme Court is saying that it expects multinationals to do what they say they are going to do with regard to their foreign subsidiaries. That principle may appear uncontroversial to your average man on the Clapham omnibus, but it came as a real shock, I think, to most members of boards in UK's leading companies. So overall, I would say that the UK courts have shown themselves to be very receptive to parent company cases. Over the past 25 years, there has been the development of a very substantial jurisprudence around this principle, culminating, as I say, in Vedanta. And so there's every reason to be optimistic for the future of human rights cases of this sort in the UK. Am I within my time?
You are within your time, and thank you for that very succinct and useful outline, and lots of food for thought there that I'm sure will generate some discussion when we have a chance to talk about this. I'll move on next, if I may, to our next speaker, who is Channa Samkalden. And Channa is a lawyer at Prakken d'Oliveira, which is a human rights firm in Amsterdam. She specializes in liability for human rights violations, both inside and outside the Netherlands. For example, she represents 4 Nigerian farmers and the foundation Friends of the Earth in the proceedings in the Netherlands before the Dutch courts in the Netherlands against Shell, relating to oil pollution in Nigeria. And the Court of Appeal of The Hague will hear the case on October the 8th. So a good combination really with Dan Leader, who's doing a similar case in the UK. Channa, I'll pass that to you.
Thank you, Richard. Yes, it's a good combination, and actually it's interesting one, I think, to refer to, because it shows also the complicated framework that we're looking at here. The Milieu Defensie case about the pollution in Nigeria has actually been the first one in the Netherlands where the courts have explicitly confirmed the option to hold a parent company liable, not yet determining about whether they are liable indeed, but the option of holding them responsible before the Dutch court, and together with the parent company involving the foreign subsidiary. That was a first, and that's at least one of the hurdles that have been taken, first by the district court and then by the Court of Appeal in 2012. But as you said, the case is still pending. I guess because it's a pioneering case in many aspects, so it's taken a long time. And what's interesting about it also is that the court must apply Nigerian law in that case, which is based on English law. So we're actually looking all the time also to what's happening in England, where obviously there is a little bit more experience with applying English law about parent company liability. So that's always a complicated aspect about parent company cases, I'd say, that we can discuss them within the framework of our Dutch legal system, but most of the time we are not even looking at Dutch law. But I am nonetheless going to refer to Dutch law because at least I'd say there are 2 points to make about Dutch law. It's quite receiving as much as that procedural law is regarded. I think that's something we'll probably enter later in this webinar. It's also quite an open system when you talk about liability in general. And quite different, in fact, from a common law system like that of the UK. For one, because in the Netherlands, we don't really make a distinction between a violation of a right, a statutory, a fundamental right, or any other kind of right, a violation of a duty, which could be a statutory duty, any other form of tort. And then there's the category that's referred to in the same article. It's all a part of a wrongful act in the Netherlands. And the final category of that article is a violation of what has to be considered to be proper social conduct. And it's 3 categories of violations that really encompass any kind of wrongful act. And that has in itself, of course, such a kind of an open system. A violation of a fundamental right could be considered to be contrary to social conduct. It could be considered a violation of a right. And in fact, you see that in Dutch jurisprudence, the distinction is often not really made as long as it's a wrongful act. I think this fits within a tradition, a Dutch legal tradition, where reasonableness, fairness have always been central ideas in the application of law. And that also allows us to bring cases when we talk about multinational companies in a wide area of human rights violations. And when we look at the cases that we've dealt with, for example, at our firm, there's obviously there's the case we just spoke about, the pollution. I think environmental cases are very suitable to be litigated abroad, also because they are very often large scale, the impact is huge. But we've also seen cases about the infringement of social rights, although they haven't been always held in the courts, but there's been a big settlement by Mead and Heineken, which was actually started as a soft law procedure before the national contact point for the infringement of social rights at its subsidiary in Congo. We have the Kiobel case pending currently in the Netherlands about complicity in extrajudicial killings. So I say it can be a large array of rights that are involved in these cases. There's the case against the Dutch Development Bank, which is largely a due diligence case for their involvement in a project in Honduras that they financed and that in the end led to the murder of Berta Cáceres and many other violations of international rights as well. So there wouldn't be really a restriction in terms of rights. It's of course very important to consider who can bring a case, and in the Netherlands that would normally be either the individual victims, but it can also be an NGO who's representing the victims. And under the current legislation, you'd have 2 choices. You can either represent the victims but not claim their concrete damages, ask, for example, for an injunction, ask for a declaration of law, which would typically be a more idealistic case in nature, or you could bring a case as a mass claim, and then, of course, it would be a case about damages, but that also increased the risks, the financial risks in the case. Was that the buzzer? I'm sorry, I'm not hearing you.
I think it was quite a feeble buzzer, but I mean, have you nearly finished?
I think I'm nearly finished. I had your question against whom. under Dutch law, then that could be the parent company. But in fact, I think the determining question is not what the organizational or the structural relationships are between the different companies, but what the active role is of the Dutch company as well as the foreign company that you are suing.
Thank you very much, Hannah. Our next speaker is Miriam Saage-Maal, who is a lawyer, vice legal director at the ECCHR in Berlin, which is a well-known public interest organization there. She has worked on various cases against corporations, including civil proceedings against German retailers relating to exploitation of workers in Bangladesh and Pakistan, and criminal cases against corporate managers involved in international crimes. He's also a lecturer at the Free University in Berlin. So over to you, Miriam.
Thank you. Thank you also for the invitation. This is a great panel. I'm very honored to be on. I had to smile a little bit that you said we should be talking about cases that can be litigated successfully, and then I felt like, well, maybe I don't belong into that panel, because I would say that in Germany so far we have not been majorly successful in at least litigating civil cases. So basically there has only been one case that is related, a civil litigation case that has been brought in German courts related to human rights violations. That's the case you already mentioned. It's against the German retailer Kick, on its responsibility for a disastrous factory fire in Pakistan where 285 workers were killed. And then there's currently a litigation pending that is related to a company's responsibility on climate change. So that's also the second civil litigation that is ongoing. But in principle, you can, any type of human rights violation that you can translate either into a tort or a personal injury under national law, or into a criminal offense, is something you can bring to German courts. And I think it's quite easy also to, like, the question of admissibility, or if German courts have jurisdiction over the case, is quite clear, at least when you talk about a parent company having its subsidiaries or directors of a company being located and acting from German territory. In civil litigation, it can only be brought by individuals directly affected, so those that have been carrying a personal injury. And also, like Channa already mentioned, in the Pakistani case that we have been litigating, due to the Rome II regulation, we were also applying Pakistani law, and thanks to the British Empire, we were able to relate a lot of our arguments to British case law, or to English case law, and is exactly the cases that you have been litigating. So if you look into a civil litigation, the main questions will be evolving around the question of whether or not there has been a duty of care of the headquartered of the parent company, or in our case, it was actually the main buyer of that factory. So we were able to prove that the retailer was taking 70% of the production of the subsidiary over a period of 5 years, that there have been at least 3 social audits commissioned by that retailer, and that the retailer itself has been visiting that factory several times in those 5 years. So that's why we felt there's a sufficiently enough close relationship that we would want to argue for a duty of care. And we basically applied, we said, well, that in Pakistani law, you need to look at the English precedents. And so we basically applied the standards that you have been litigating, or you've been established through your litigation. I do have to say, if you were applying German law, it would be quite similar arguments you would make if you wanted to establish a duty of care. We used a second argument. We also used the argument of vicarious liability. Again, where we also looked strongly into British law, or English law, I think you say. But there's an interesting development currently in the German debate around vicarious liability, because it's actually more and more there has been one. So in the legal debate, it's more and more considered that you could actually argue that a company, a subsidiary belonging to a group, a larger group, a corporate group, that the parent of that group that the subsidiaries in that group may be considered vicarious agents, which would also then widen responsibility of the headquarters towards the subsidiaries. That's quite remarkable, because usually German civil jurisprudence is very conservative, but there is a really growing momentum in that. And also there has been one important case where the court has held that the headquarters of Siemens, based in Germany, bears a duty of care towards its subsidiary in Nigeria when it comes to corruption. So they were directly held liable for the corruption that has been happening in Nigeria. Now, this was not a third-party tort case. It was about whether or not it was sort of an internal corporate litigation. Still, that holding is quite important. When you look into criminal law, which is also sort of from the tradition of where German, sort of the German legal tradition, it would be the first step that you would expect the authorities to investigate into a crime that has been committed. And then you would attach your civil claims to that criminal investigation. And then anything that has been investigated during that criminal trial would then be used in assessing the damages and the amount of compensation that needs to be paid. So that is quite a viable road. Again, the main questions that are revolving around is the question of attribution. So normally the individuals, we don't have corporate liability under German law. So you would always need to find a person that you can attribute the criminal responsibility to in the German headquartered company. Usually those actors are not directly, obviously, involved in the crime. So there's always the question, has there been a duty to act? So, can you say there's an omission liability in there? So, and again, we're quite in this same line of argument. So has there been a duty of, basically a duty of care? Has there been a duty that this particular person from the position in his company should have done anything to prevent the crimes from happening on the ground? So this evolves a lot around negligent behavior, and also what we're trying to use is otherwise the concept of aiding and abetting, which then also has its difficulties, especially when you think about the mens rea standards. In criminal law, we've just been recently bringing with a larger group of persons. The advantage of criminal complaints is they can be brought by anyone. They can be brought by civil society organizations, and with the civil society, you can also represent individuals that have been victims of the crime. If you're representing victims of the crime, you have a much stronger standing in the case. So you can actually, once the case goes in the pre-trials, you have quite some access. You have access to the files, to the investigations. And in the trial phase, you also have, the partie civile has quite some far-reaching rights. Again, not as much as France, but at least some. So an example of a criminal case that we have been bringing is we have been filing a criminal complaint in Italy against the management of a German subsidiary that has been producing bombs that are exported to Saudi Arabia, and where we have found a remnant, or not we, but a remnant of that bomb was found in a destroyed farmhouse in Yemen. Where it was clearly a civilian target. It killed a whole family of 6 people. And we were able, due to that remnant, we were able to trace back to the production site in Italy. We decided to first try to instigate criminal investigations in Italy, and not directly go against the German managers in the German headquarters, because we exactly felt that we are not able to have access to any evidence of how the management in Germany is actually intervening in decisions in Italy. I'm very convinced they do intervene, but we just simply felt we have basically up to no evidence, which I think is something we're going to discuss in the next round as well.
Thank you, Miriam. That was very interesting. And you started off by giving the impression that not much was going on in Germany, that it was all hypothetical, but you're certainly doing some very interesting work there. So thank you for that. And last but certainly not least, on this question, we have Sandra Cossart, who is the director of Sherpa, a very well-known human rights organization, law firm in Paris. Sandra has previously headed the Globalization and Human Rights Program for almost 8 years, during which time Sherpa was at the forefront of some of the most important milestones in corporate liability for human rights. Sandra has played a pivotal role in the development of the groundbreaking duty of vigilance legislation that was adopted in France in March 2017 after 5 years of intense advocacy work. So over to you, Sandra.
Well, thanks, Richard, and thanks for the invitation. I'm very honored to be speaking with a great practitioner. Concerning your first question, I think I would like to raise 3 points. First would be something about criminal liability. The second would be the attempt we had at Sherpa to try and transform soft law and self-regulation into hard law, so using contractual and consumer law. And the third one is about the new avenue that, as you mentioned, the duty of vigilance helped to open. So briefly, on criminal liability of French parent company or French directors, there are some very interesting features indeed of the French criminal system. First, we have provision on the right of victims or civil party in criminal proceeding, as Miriam was saying, including for NGOs. And this is a major point we can discuss later, as for legal standing, at least the legal standing under French jurisdiction seems to be under attack from the government as well as from judges. But we also have provision on criminal liability for corporation, and it's recognized under French law. And also provision on extraterritorial jurisdiction of French court in criminal matters, including provision on universal jurisdiction. So all these provisions have led, I guess, to some recent development and successes. And I can mention briefly 2 successes that we had recently. One is on Lafarge, the indictment of Lafarge, which is a Simon company, for complicity of crimes against humanity and endangerment in Syria. A case we've developed with ECCHR, and have to mention though that the decision has however been partly overturned on appeal, and now we are before the Court of Cassation. I can also mention briefly the opening of formal investigation against Vinci for forced labor and endangerment on its construction work in Qatar. Well, even though we have some success, I still need to mention that there are still many obstacles that exist. Among other, the extraterritorial jurisdiction is still limited for offenses that are not crime. And also the fact that criminal liability regime of corporation fails to take into account the reality of multinational corporation, because it does not challenge the corporate veil between a parent entity and its subsidiary. The second point I wanted to mention is how we try to use the contractual law and consumer law. So transforming soft law and self-regulation into hard law. We indeed try to use other legal bases to hold corporation liable before court. And we did so in using labor law when we defended 850 Congolese workers in our case against Comilog. I'm not sure I have time to speak about all these cases, so I just mention them and then we can come back if needed be. Also, we use the contractual law in our case against Soca Palm, which is involving the group of Bolloré. So trying to transform what was a declaration before the French national contact point into a contract in agreement, because Bolloré had signed an agreement with Sherpa before this national contact point. And by not respecting this agreement, we consider that it was a violation of the contract and agreement. And maybe the last one I can develop a bit further is on consumer law, as we have two cases you might be aware of, one against Samsung and the other one against Auchan. There was a recent success last year in the area of consumer law, as Samsung has been indicted for misleading commercial practices after almost 8 years of procedures. And it has been indicted on the account of the gap between its ethical declaration on the one hand and reported abuses in suppliers' factory in Korea, China, and Vietnam. So this was a big success. Yet, this cause of action is limited, as it does not provide remedies for direct victims. Indeed, if we win the case, it would only provide remedies for French consumer because it's under misleading commercial practices. And the third point I wanted to mention briefly is obviously the new avenues that are now open in tort law with the French duty of vigilance. And there have been very few cases in tort law. And one of the main reasons is indeed the question of access to evidence. There is very limited access to evidence in possession of the company itself under French civil procedure. That would be necessary to prove a French company's involvement in abuses abroad. Hence, the use of criminal law, where both prosecutor and investigative judges can have access to more decisive evidence. The other main obstacle is, of course, the corporate veil that we've been all mentioning. French companies are operating abroad through separate entities, whether it be subsidiary, subcontractor, supplier. So if the French jurisdiction of French courts over French entity is easy to establish, it is very tricky, well, at least until the duty of vigilance, let's hope, to attribute a wrongful act to the French entity itself. So we consider that this has changed with the adoption of the law on duty of vigilance in 2017. Well, a law that obviously we've been fighting for years. And obviously the existing legislation is not what we wanted. It was much more ambitious, but this is the result of a political debate. So the French duty of vigilance requires large companies to establish, publish, and effectively implement a plan. This vigilance plan must contain adequate measures to identify risk and prevent human rights and environmental violation. But since last year, tort action may be initiated in France under this duty of vigilance. So this is a welcome development, and even we can consider it an historical step. But it also raises a lot of legal questions, and I'll finish with that. In particular, on how to prove causation between a company's violation of its duty of vigilance and human rights and environmental damages goes further in the value chain, and that will come up definitely, I think, in the next cases. And also, companies are supposed to publish a vigilance plan. The burden of proof still falls mainly on the claimant, so that the duty of vigilance does not resolve completely the obstacle linked to access to evidence. And I'll stop that for this question. Thank you.
Thank you very much, Sandra. Now, as I said earlier, I think what we can do now is have some time for discussion, maybe up to 10 minutes. A number of questions have been emailed through to me, which I'm going to raise with some of you in a moment. I sent one question of my own really to start off with, which is both Hannah and Miriam have referred to the unusual situation where their courts in the Netherlands and Germany end up via the Rome II regulation, effectively having to interpret English law, which then puts a lot of pressure on Dan to make sure English law is progressed in the right way. But I mean, more generally, in your experience, how different are the laws of other countries when it boils down to it? Because I know certainly from my experience of having to look into the laws of other countries, they often seem to amount to more or less the same thing. They provide remedies for more or less the same thing. I don't know what your experiences are. Perhaps we can start with you, Sandra, and see what your feelings about that.
Well, I guess from our experience is that when we've been also litigating in various countries of Francophone Africa, it is indeed very similar to the French code. In terms of more continental law, I would say, yeah, if you look at how it, whether it provides remedy for victims, yeah, but then I guess we would need to go also into the details. And what could be also an obstacle is that it's very tricky for a judge to think that he or she would have to interpret a different legislation. You have to think that especially French judges don't speak English. So not even mentioning interpreting a different legislation, just having to be in contact with various people of the case from another country is already a major issue. So interpreting another legislation is like stepping back and not taking the case. That could be also one of the reasons why we have so few cases on that. And I think, I mean, we maybe less, international and less open-minded because not everyone speaks English in France. But I think that's an obstacle for the French jurisdiction.
If I can just move on to one of the questions that's been asked, which I can put to a couple of you. In fact, I can wrap two questions into one because someone has asked about the criteria that are likely to give rise to the imposition of a legal duty of care on a parent company, and someone else has asked about the supply chain scenario. So I think if we could link those two things together, perhaps I could ask Miriam and Hannah about in what circumstances you think a duty of care could be imposed, let's say, on a retailer for injuries or harm that occurs in a supplying factory in Bangladesh or Pakistan or in another developing country. What kinds of scenarios do you think would be sufficient to give rise to liability? Maybe start with you, Miriam.
Yes. Well, to start with, I would say that I think it will only be in exceptional cases that you can actually really argue for a duty of care, as far as I would understand, and that's both for how we have been interpreting the English law and jurisprudence on this, and also if you look at German standards of law. So obviously you need to have the parent or the buyer must be able to have some sort of, you need to argue for some sort of control, and you need to be arguing for some sort of ability to influence the situation in the subsidiary. And generally, so there must be a certain kind of closeness. That's the word you would use in Germany. And so what we've been trying to argue is that how do you argue for control? So, well, if you are the buyer over, so length of the business relationship is 5 years, it's the majority of the production. So that means you do actually have influence, you can exert pressure. I would now even say also after what we've been seeing in the COVID crisis, how brands can just cancel contracts with absurd legal arguments and go get away with it and not paying for already produced goods. So that really shows there is a power relationship, and that means you have control, you can have influence situations. And that, yeah, so I think power, ability to influence situation. Then of course there must be a knowledge element too. So there must be somewhat, and that's where things get tricky. So you must be arguing that there was some way of knowing about the precarious circumstances in the subsidiary. We argued that as they have been visiting the factory undoubtedly themselves, and you could, with your bare eyes, see the fire hazards that were apparent in the factory. Plus, you had but then comes a question of social audits, right? So because the defendant will say, well, we've done social audits, look at the report, they say everything is fine, so we had absolutely no reason to believe that we must be even intervening. And I think that's a whole different area, at least when you look into supply chain, the question of liability. I think also to talk about the liability of auditing companies, because otherwise the brand will say, I had a social audit, I couldn't know, and therefore I'm not liable. And the audit company will say, well, we just did an audit, we're not liable to anyone except the company that gave us a contract to do the audit, but definitely not to third parties.
Hannah, have you got anything you want to add to that?
Not really. Well, I think maybe just the remark that I think this, what Miriam says, identifies indeed the general principles that we see also in Dutch law and also, I believe, in English law to establish whether there's a duty of care when this is not already obvious. What I wanted to say is there can, of course, be legislation that explicitly determines that duty of care. Like in the Netherlands, we are really not at the forefront when it's about legislation. But there is a new law that has been adopted about child labor, for example. So there is the obligation for a parent company to make sure that there's no child labor in its chain. And I'd say when applying the framework that Miriam also was talking about, there is no real difference as far as I'm concerned, between a parent company or any other company in the chain, as long as indeed you can establish that there is a level of control, of knowledge, and a position to actually make a difference there.
Yeah. Sorry, I was going to say that I think that you made that point very well at the end, Hannah. Dan, there's another category of case that Sandra mentioned, which you have some experience of, which are the so-called corporate complicity cases, where human rights violations are alleged against a company which is said to have colluded or worked in conjunction with public or private security. And you did the Gemfields case last year, which was an example of that. I mean, perhaps you could just give us some insight into what you would need to prove in that type of case in order to secure the imposition of a duty of care on the parent company.
Yes, I mean, I think the headline point I would make is what's been very interesting over the last few years is because of essentially 3 cases that have been going through the appeal courts on parent company liability, Vedanta, Shell, and Unilever, we've seen a refinement of the principles by the Supreme Court. And essentially the High Court and the Court of Appeal approached the imposition of a duty of care through a very restrictive prism. What they were looking for was operational control of day-to-day activities. The word control is absolutely central to their analysis. But and in some cases very unfairly said, well, you don't have the evidence of the internal emails of company X telling company Y what to do, therefore your case can't proceed. How victims are meant to get hold of that evidence at a pre-disclosure stage is very questionable. But what the Supreme Court does in Vedanta is it actually says that the scope of parent company liability is much, much broader than the way in which the Court of Appeal has been interpreting it. It looks at not only control, but it looks at advice and supervision. And in addition, it looks at the policy framework and public undertakings given by parent companies in their literature. Now, all of this was totally ignored by the Court of Appeal in their analysis of the cases. So that's why Vedanta is such an important judgment. It broadens out the scope of parent company liability. And we'll see, incidentally, whether the Supreme Court builds on that in the recent Shell case, which they've heard just last week, to do with Shell's pollution in the Niger Delta. With regard to corporate complicity, I mean, those cases are brought on precisely those principles. Is there sufficient evidence that the parent company in London or The Hague or Paris has been essentially interfering or in the affairs of the subsidiary in a way that is relevant to the human rights abuses which have taken place? So were they making public statements about the human rights abuses? Were they involved in training? Was there a centralized corporate security function which gave advice to their subsidiaries, which many multinationals do have precisely that? That's the kind of evidence the courts are looking for. But not only that, they're also now looking at the policies, and they're looking at what the corporates are saying about human rights. And in that sense, for the first time in Vedanta, I think what we have is a potential bridge between legal liability and the cases which have been developed over the last 25 years, but also a bridge with the soft law mechanisms which are developing in the UNGPs. You know, for the first time, there's a connection between the two, which I think is logical and important.
Thanks, Dan. Let's move on to our next question so that we can maintain some momentum. What's the next question? Can we have it up? Okay, so what procedural evidential rules are of particular relevance to the cases in your countries? I think this question is much more interesting than it sounds, just looking at it there. But maybe we can start with Sandra this time.
Yeah, okay, maybe I'll go quickly. I had 3 points, but I'll speak about 2 only, I think. One is about the legal standing of NGOs I was mentioning earlier. The second one is about discovery of internal corporate documents and the burden of proof. And the third one that I might not be speaking about is collective action. First, the legal standing of NGOs, because it's crucial for us. The rules on legal standing of NGOs is very relevant as the direct foreign victims may not have the sufficient resources, the legal knowledge to initial legal action, or also most of the time may fear reprisals. As you know, in most of the countries where we are defending victims, there are a lot of violence against human rights defenders. So, as mentioned before, NGOs may have legal standing in criminal and civil proceeding under French law, but there has been a restrictive movement in recent years, both in legislation and case law. And today, this is an area where we have a legal uncertainty, as shown by the decision in Lafarge case, where Sherpa and ECCHR have been found inadmissible for lack of legal standing. And actually, this issue was raised in almost all of our cases, whether it be Vinci, Samsung. So it's something that we need to take into consideration, and also mentioning the legislative process, as the legislature has put more and more burden on the standing in the legislation. The second point is the discovery of internal corporate document and the burden of proof. So you may know that there is no such a thing as discovery of internal corporate document under French civil procedure. So we are very jealous about what is existing under the UK law, and access to evidence is very limited. I'll give you one example in our case against Pear & Co. We've tried to rely on an existing mechanism, and in particular, the ex-ante investigative measure that may be requested to a judge before any claim is filed. And this is usually mostly used in an intellectual property case. Yet, the case is a good illustration of the limitation. This case relates to allegation of pollution resulting from Pear & Co.'s activities in the DRC. And last July, Sherpa filed an ex parte request for investigative measures under the French School of Civil Procedure, including the seizure of documents within the parent co's premises relating to its corporate structure and its involvement in the alleged environmental damage. Well, this request was granted by the judge, yet the company obstructed the enforcement of the court, preventing the judicial officer from entering its corporate premises. We requested another measures, but it was rejected by the court. The hearing on the appeal took place last week, and we are expecting a decision in September. So you see, it's a long list of obstacles. So in face of all of these type of obstacles, there should be specific mechanism to access documents or information detained by companies when their environmental or human rights impact are concerned. Even I think if we need to take into consideration something that you were under pressure is that disclosure process can be used by a company to draw claimant under billions of documents that then require extra expertise or financial resources to be examined. So this would need to be taken into consideration. But at the moment, we are not there yet because there is no such a thing as disclosure process. And I think, yeah, maybe just briefly, the rule of the burden of proof also should be reformed to take account of the fundamental imbalance between victims and corporations in those cases. And in fact, the duty of vigilance cases are bound to be limited because of the difficulty for victims to prove a company's breach of its duty of vigilance and the causal link that breach and the harm suffered. So we'll see how the jurisprudence will develop, but that's something we had in mind, and that's actually something we had put in the first version of the duty of vigilance legislation, the reverse of the burden of proof. But for political reasons, that was not acceptable. So we ended up with what we have today. But I think we still need to push for that, you know, in terms of advocacy, to have somewhere the reverse of the burden of proof. And I'll stop there, and I won't mention collective action, I think, so that everyone can speak.
Thank you, Sandra. I'm obviously, access to internal corporate information is vital in all these cases. It's as important as having a legal basis for a claim is being able to get information which will enable you to prove it. It's no use just having the remedy without the means to achieve it. Thank you. Can I ask Miriam then to tell us about the situation in Germany?
Yeah, similar to what Sandra said, we also don't really have a discovery procedure, neither pre-trial nor in trial, really. I think, so how we have been trying to deal with this is one that I think we are simply very reliant on publicly available information. And I think the advances that open resource research has made, I think is also definitely helping those cases. If I think of our cases against the European arms traders, there's a lot of open source research on this, on the question of how have the arms been shifted, and so because that's a completely opaque question. We have there been less successful finding, it's still more difficult to find information on corporate internal decision making. I think something that I'm sure Sandra would confirm, what was very remarkable in the Lafarge case is obviously if there are leaks out of the company and if internal documents and communication is being leaked. So I would say the role of whistleblowers is really important also for advancing those cases if there's a huge absence, and the protection of whistleblowers even more, no? There's a large absence of discovery. And then the other aspect where I've thought it's also, again, not necessarily much related to the real internal decision-making, but again, has been an important source of evidence for us, are proceedings that are ongoing at the level, at the local level where the harms have been occurring. So, for example, we have been bringing a case against the Nestle headquarters on the murder of a trade unionist in Colombia, and there has been in first instance judgment that has been from Colombia, sort of laying out all the facts of the murder that actually occurred and convicting the direct perpetrators of the crime. and then sort of hinting towards the links to the company. And so that meant we were able to sort of have the full, we could use that judgment. We've been doing the same for Pakistan as well, so that there's at least one layer of facts is quite well established. And then you need to only think about how do I make the connection to the headquarters and to their internal thinking. I think one way of how civil courts in Germany deal with that fact in favor of claimants is that I would say the amount of information that needs to be brought when you bring your claim to substantiate your claim is not as high. The threshold, I would say, is not as high as it would be, for example, in a UK court. So in the case, we were basically relying in terms of what's been happening in the company only on their public statements, and they have been a little bit unwise, I would say, in the beginning of the crisis on how they communicated about this. And then how the procedure goes is, so the claimant must be bringing sufficient information, not necessarily even proof, but substantiate the claim. And then it's up to the opposing side to question that. But it needs to be explicitly said, no, we're questioning that is wrong. And then the court will put the burden of proof on the claimant to say, okay, prove that one point. Now, if the other side is not contesting all the allegations you make, that means they are accepting at least parts of the allegations. In the Kick case, we were lucky enough that the company felt it would be really, I don't know what they thought. Well, for some reason, they thought they can't go back behind what they have said in public. So it was never a debate whether they actually bought 70% of the production over a period of 5 years, for example. It was also never a question whether they have done social audits. So that, I don't know. So that played, you could either say it was because the other side was stupid, but I would also say it has something to do with how civil procedure works, that you may not be contesting all the information that is shared, but that because also the courts I think the courts generally accept a lesser threshold. Also, when it comes to really internal decision-making questions, courts can also decide to shift the burden of proof. They can say, well, that is a question. If company or defendant, if you claim that, then you will also need to prove your claim, your defense. No, so they may put this sort of, if the company said, oh, we never heard about this, or we never discussed it, then it's quite possible that the court will say, well, you need to somehow put some backing to this, so that the company itself will need to reveal some of its internal decision making. Again, I still would say, and that's also what we're advocating in the currently ongoing law reform. We're also part of the coalition that asked for a human rights due diligence law in Germany, and that is clearly one of the demands, that there must be at least an ease of the burden of proof, if not a reversal of the burden of proof, because that is a major obstacle.
Thank you, Miriam. Interesting discussion about the reversal of the burden of proof. It would obviously be an important advance in places where you don't have effective disclosure procedures, but I'm not sure that it is the complete answer. I don't think it is, but Hannah, let's move on to you.
Thank you. I think the general system is quite similar to that in Germany and even France and the Netherlands. We also do not have a system of disclosure. We miss it all the time. I'd love to have a phase of discovery and an obligation for the parties to disclose whatever documents might be relevant. It's just not the case, and simultaneously you are in a position where, as a plaintiff, you will have to prove your case. So it puts you in a very difficult position. I think that position has been effectively used by Shell, for example, in our Nigeria cases, where you see that they just refuse to share the information and not disclosing anything, even in the written arguments, basically, and then using that lack of information to state that you're nowhere, you can't make your case, basically, you won't be able to substantiate it. Until now, the Dutch courts have not been too eager to to translate that into a change of the burden of proof, or maybe a lighter threshold there, or even reversal of the burden. So that hasn't been too successful. It could be nice, I think, especially in a situation where it's quite clear that a company must have certain internal documents concerning your claim. It can't be that they profit from the fact that they're just unwilling to share that information. But where it's brought us, we have to be creative in the cases that we do try to get the information in any way that we can. In the Netherlands, one of the options we have is we can file a petition for disclosure in courts, and the legal provision says that you're entitled to get certain documents if you can show that you have a legitimate interest in those documents. If you are a legal party, doesn't necessarily need to mean that you are involved already in a court case. It can also be preceding a case. It can be a case even going, or one that you are thinking about in the Netherlands or elsewhere abroad, as long as you can establish that you are in a legal relationship with the party that you're demanding the documents from. And one aspect of that provision that has been problematic in the past is that you need to ask for particular documents. And it's still not very clear how concrete you must be. I mean, there have been courts that have allowed claims for information, but for example, in our Shell case in first instance, the court just thought we couldn't make clear sufficiently what type of documents we were looking for, because we simply didn't know the names, we didn't know the dates of correspondence and so forth. And so that can be a difficult aspect there too. But there have been some changes in Dutch procedural law, and there is an indication that it should be easier to get information preceding the case and to bring parties into the position to really determine also whether you can bring that case without having to jump into it immediately. So we hope that we can see a more flexible approach in the future. And also the Court of Appeal has in the end allowed our request for disclosure in the Shell cases. But there are other options too. We can have preliminary witness hearings, which can be interesting. But it's very often a strategic discussion, strategic choice, of course, whether you want to do that. We have the general data protection regulation that can already disclose some information. Also the Freedom of Information Act, even when it's not a case against the state. We had a case pending against the FMO, the Dutch Development Bank, which is not a state institution, but is very closely related to the state. We made a Freedom of Information request, and that already provided us with information that was already quite useful for the cases. Well, even just because it gives you more background, it gives you new leads, it gives you some hints maybe on where you might want to seek further. And finally, I think not to be forgotten, you can, like our legal system allows us to make petitions for disclosure also for foreign jurisdictions. The US does the same. We effectively used that in the Kiobel case when we tried to get the documents that were used there in the preceding Kiobel case in the United States. And we asked those documents from the Shell lawyers in the United States. So I think it's definitely an interesting aspect to look into when dealing with these cases, not just stick to your own jurisdiction, but also look beyond. I think that addresses at least the discovery part for now.
Thank you, Hannah. Thank you. Dan.
Yes, so in the UK, the burden of proof in civil litigation is clearly on the claimants. It's for the claimants to prove on the balance of probabilities that at trial that the defendants are liable. And at the jurisdiction stage, they need to persuade the court that there's a real issue against the UK domiciled defendant. So as long as you get past the jurisdiction stage, then you get disclosure. And that is obviously the huge advantage we have in the English jurisdiction, because our disclosure rules are onerous. The defendants both parties, in fact, are legally obliged to essentially disclose all documents which either support their case or are adverse to their case. And that's obviously a nightmare scenario for a lot of defendants, because they will be forced to hand over internal documents which go precisely to information that they want under lock and key, which is about the nature of the internal relationship between head office and their subsidiaries around the world. All that's relevant to the issue of parent company liability. So the strategy of defendants, therefore, is to try and avoid getting to the stage of disclosure and to fight jurisdiction absolutely tooth and nail, because they don't have any disclosure obligations until they get past jurisdiction. And that is the common example that Hannah and I can share with you, the Shell example, where they have disclosed almost nothing in the context of the jurisdiction arguments, and stood up with a straight face to the judges and said, well, the defendants have absolutely no evidence. Sorry, the claimants have absolutely no evidence of the nature of our corporate relationship. And you can't possibly rely on public documents because they can't be attributed to Royal Dutch Shell, which is obviously a no-win position for claimants to be in. And so, yes, we have highly advantageous discovery rules, but it doesn't mean that the same tactics are not deployed before we get to discovery. And that's a major challenge that we face. And that's why we need to be thinking much more laterally about pre-action disclosure, about whistleblower evidence. All of this helps to tease out the true nature of the corporate relationship. But it's a very big hurdle for claimants, and certainly something I spend a lot of my time doing is looking at the evidential thread as to what can we prove is the nature of the corporate relationship. Do we have enough evidence to put forward a credible case to the court? And it's only if we do, only if we are feeling extremely confident in our case, that we put it forward as a claim. It means a lot of cases can't be pursued for precisely that reason.
Thank you, Dan. Now we've got some questions from the other participants, which I'll ask you. I'll direct you. So the first one, actually, Dan and Hannah, I guess is most obviously for you. It's about how can you compel disclosure of group-wide corporate directives from within the multinational group? How can you compel their production?
I can at least try to answer the question. I think at this point in the Netherlands, you can try, as we did through the disclosure petition that we did. And in the end, that gave us part of that framework that applies, but only a very limited part. And in first instance, for years, we did not manage to compel them to disclose the documents. It was only after we, through another way, got a part of it, and when our own information became much more concrete about how this worked within Shell and how what types of documents and manuals and so existed, that we were able to make our own petition much more concrete. And I think that in the end made it also much more successful. But what you need, of course, is to establish within a legal framework that if it's established that with a certain degree of control and probably a certain framework that a parent company can be liable, then you also have a legitimate interest in getting those documents that actually are at the basis of the way wherein the company exercises that control, or at least it's one has sought to exercise the control. But I don't think we are there yet at this point.
And Dan, I guess in the context of a claim in the UK, if corporate documents are not disclosed as part of the normal process, it's possible to obtain their disclosure through procedures like specific disclosure.
Yeah, so, I mean, even though we have these very onerous rules, corporate defendants can actually try and play fast and loose with them. So they can assert privilege over a vast array of documents. A lot of the fight around disclosure can turn around search terms on the electronic search engines that are put through their systems. And that can often be a debate you'll have to have in court as to what those search terms should be and how many custodians they should search. And all these things will be essentially resisted by corporate defendants who want to limit the ambit of disclosure as much as possible. We recently had this on a case against Ernst & Young, where we had to go to court. They disclosed something like 300 documents relevant to a 4-year period from numerous different custodians. We had to get to court to convince them to open up the disclosure to more custodians. So even though we've got much better rules, we still have to fight for disclosure because generally companies will do everything they can to avoid handing over documents.
And Sandra, Miriam, there's a question about challenges to corporate criminal liability. And I mean, it's a general question, but I'm assuming that from what you've said that the standard of proof is one aspect. You've got the benefit of if the criminal procedure kicks in, a way of getting evidence. But what do you say about that? What are the real hurdles when it comes to criminal liability? So let's start with you, Sandra.
Well, I guess maybe considering other jurisdiction, this is where France may have an advantage, as you know, because I mean, NGOs could be a civil party, so where then the prosecutor has the ability to close the case, but then we could force the nomination of an investigative judge by being part of civil, and then it's up to this investigative judge to do the research and go and ask for documents. And this is why for the last 20 years, since the existence of Sherpa, most of the cases we have initiated are on a criminal basis. It's more recently that we've said we need to open the avenue of civil litigation. So, I mean, in terms of if I had to defend civil versus criminal, I mean, criminal cases is easier. But then you have the filter of what we call the parquet, so it's the prosecutor, that for most of the political reason they close the case. And if it was not for the legal standing of NGOs, then none of the case like Samsung or Lafarge or Vinci would have seen light. So this needs to be conserved, and I think we would like to take it to a European level, so that there is this kind of legal standing for a civil party at the European level.
Thanks. Miriam, anything to add?
Yeah, probably to add to this, I agree with Sandra that to bring a case or to file a civil criminal complaint, exactly, I think that is in that sense easier because you don't have a certain threshold. I think on how then courts and prosecutors deal with this, obviously, they have a lot of investigative powers, and I think if they're willing to take advantage of those, then obviously they also have access to corporate documents. So I would also say that in those terms, it's more of a question of political willingness, and probably also depends on which prosecutor office you are at. So For example, in a recent case that we've been bringing with regard to an auditing company that audited a Brazilian dam that collapsed, the Brumadinho case. And we've been bringing charges against the German headquarter of this auditing company. And that case is now being dealt with the corporate crimes unit in Munich. And that's the unit that has also been investigating all the corruption charges against Siemens, for example. So they have a very confident way of how they think they're going to go about this case, and how that they are actually going to look at the documents, internal communication. So it depends on, you're very dependent on what type of prosecutor you are finding. And then I would also say, then again, of course, the biggest problem in criminal trial is then the mental side of the crime. So you will always need, at least if you talk about individual liability, you will always need to prove that knowledge is either knowledge standard or should have known standard, and how to find the evidence for that. And I think as a structural problem, if you talk about headquarters responsibility, it's probably a lot, if you also even think about what was the mental state of the corporate officers involved in the situation, it was a lot of times probably really negligent. And then that means that, but not a lot of the crimes will be applicable. But anyways, there are also, again, we've been bringing a criminal case alleging causing a flooding, which is actually a crime in Germany, and that is extraterritorially applicable. And it's also something that you can actually commit, a crime that you can be committed negligently. So, I think if prosecutors were more aware of those cases, were better equipped and a little bit more courageous, I think there could be many more investigations ongoing, and I think they would have a lot of leeway of really looking into corporate internal affairs and also their thinking, which then I would think would turn out to much more often to be actually criminal than we would think.
Well, that's very interesting. Thanks, Miriam. Let's move on to our final question. We could just have that on the screen, please. Right. So this is part of the title of the webinar, of course, strategic litigation. And what we want to know is, how do you decide which cases you're going to take forward? And in public interest cases, how do you reconcile sometimes differences of interest between victims and the wider public interest? Who hasn't been first? Shall we start with Hannah?
Thanks, Richard. I think in the end, as much as I would like it to be a matter of principle, which definitely in part it is, but I think in the end it's very much a decision you make on practical reasons, or it's a matter of what the practical circumstances are, because in these types of cases, obviously the legal field is still very much developing, and you want to make a decision as to sufficient chance of success within the currently existing legal framework, but still pushing it a little bit, I'd say. So that's a principal aspect that you can think about. But whether that case might be successful or not is determined by how are your local contacts. I mean, this is about foreign cases. So is there an NGO supporting the case that has a solid foot in the ground there that can help you doing your research? How much do you know about the company? Because you don't have anywhere to start if your basic position in that regard is not good. In the Netherlands, and I think in all jurisdictions, basically the funding, of course, is a huge issue here. Our Nigeria case has been pending since 2008, I believe. I mean, it's very costly to have cases that complicated and pending so long. So in the Netherlands, for example, there is sometimes the possibility to have legal aid also for foreign claimants. It's a difficult route, but it certainly makes things a little bit easier, because we don't really have a developed system of third-party litigation, at least not for the cases that are not typical mass claims and not that commercially or attractive, or that you don't expect to get a lot of damages out, basically. So I'd say it's a combination of those different aspects. It's funding. Are you able to get the proper experts? How are you going to prove your case, basically? And do you have, besides the claimants, an NGO there who might be a claimant, who might not be, that has sufficient, not just money, but also the willingness to sit it all out? Because you can't really afford to have a claimant or someone involved that says when you're halfway through, well, I'm sorry, we didn't really expect it to take this long. We don't have the people anymore. We don't have the knowledge anymore. So you really need to be prepared in that regard.
Thanks, Hannah. Sandra.
Well, I think this reflection is really closely linked to Sherpa's mandate and the fact that it differs from a law firm's mandate. I mean, since our creation, we've considered ourselves as a hybrid model, like, between NGO, think tank, and lawyers organization, but with a specific mandate, which is using and developing the power of law to address corporate impunity in globalized context and provide remedy for victims. But when it comes to decide on, obviously, the NGOs, perspective weight in. For example, in some of the cases I will mention later on, as we had to decide whether we should be considering the victim's perspective or being like the public interest perspective, and then we decided that we would go for both, but then provide for lawyers for the victims themselves, as they could be willing to negotiate with the company, whereas as Sherpa, as an NGO, we would, for example, not want to negotiate with the company and have a final decision before the court. The fact also that our strategic litigation case often fuel our advocacy for legislative reform, like the Lafarge or Vinci or Auchan, were decisive in the debate on the law and duty of vigilance. So we defend victims of economic crime, but we also advocate for systemic change, and both are intertwined. So I would say some of the factors the criteria is that whether it falls obviously within our mandates and expertise, whether Sherpa brings value added in taking the case, the impact of litigation on victims, obviously. So whether this litigation will help them or, on the contrary, make the situation worse. The innovative nature of the legal basis, because that's something that we are really keen on. How it relies on our legal research and development work, because all our cases have to be, based on our research. For example, Samsung and Auchan are based on misleading commercial practices. Once we ensure that the jurisprudence is settled, then we'll move on. We won't take 10 cases on misleading publicity. And the same goes with other legal grounds. Also taking into account the policy impact of the case, could it bring about systemic change? Whether the case could feed or illustrate our general advocacy to facilitate access to justice, strengthen corporate accountability, and also preserve a civic space. The legal impact of the case, whether it could strengthen case law or the interpretation by the court, or the contrary, weaken it. Possibility also, as Channa mentioned, to build partnership with the local organization and communities affected. Because unlike a big organization, Sherpa does not have its own global network. We'll build partnership with local organization, trade union, or communities for each case. And yet maybe the difference with the law firm is that we might be less risk adverse than lawyers when it comes to the likelihood of winning the case, because we also want to explore the current limitation of the existing legal provision and mechanism. So power in losing the case, I would say. It doesn't matter if we are almost sure that we will lose the case. we still would take it, if it goes in our strategy, to expose the fact that the existing legal framework is inadequate for the protection of victims. And the same goes with the cost. It's not a decisive factor either. Maybe also because I guess it's not the same kind of amount that as in UK and the US, but also because we are not there, you know, to also earn money, but really to try and expose the inadequacy of the legal framework. So Sherpa specific mandate has also an impact when defining the goals of the strategy of each case. We do, and I was starting with that, and I'll finish with that. I mean, we do understand that victims may want to settle, as it happened in our case, for example, against Total in Burma. But because we also pursue more general and systemic goals, we advocate for an independent legal standards of standing of NGOs, as I mentioned earlier. So then we, for example, in Lafarge, we decided that the victims and the NGO would be represented by different attorneys or lawyers in order to preserve their possibility to settle and the possibility for us to continue the action to expose the fact and address corporate accountability in armed conflict areas, taking this particular case. So I guess this is where we may differ from some of you looking at the cost and maybe the possibility or not to win a case. You're on mute, Richard.
I'm on mute. Yeah, sorry. Thank you, Sandra. And over to you then, Miriam.
Yes, I think a lot has been said already. I would also say, sort of from assessing the case, obviously it's the question of the solidity of the facts is important, because I think, you know, bringing a case that is very weak on the facts is very risky of setting bad precedents, or, you know, just even setting bad publicity. No, so I think the facts are really important, and then usually we are trying to strike a balance between also solidity of the legal argument and the question of how far do we want to push the boundaries, right? And so, because we also would see ourselves as in that we are there to create innovative arguments that bring debates forward, but still we don't want to be just bringing a case, you know, we always find it's a balance, because it should not give the impression of being a frivolous case, right? Because I think that's what the other side would and could then easily say. So that's somewhat of a balance. And then also for us, the whole question of how can we engage and entertain a trustful relationship, communication with the persons affected that are actually going to be represented. And then also for us, it's a consideration, how are those individuals situated in their community or in their context, social context? Because I think what is important to also make an assessment of how much personal risk do they face. How is the community going to, you know, deal with certain people going forward with a case and others? So there have been cases where we felt it will not be possible for us, not anyways, but also not for anyone on the ground that could be a sort of an intermediary. They could be moderating the question of, so why are they bringing a claim and we can't? And so that's why we felt like we can't take over that responsibility of blowing up a whole community. So we've been stepping out of cases. And then, of course, also as more as an organized as an NGO, as an NGO where also lawyers are working in, we of course have this, we call it sometimes, or this idea of that comes from our US colleagues, right, of winning through losing. So that's also what Sandra mentioned. So bringing a case, knowing that you will probably be likely to lose it, but you're losing it, we would say, on good grounds, so that it really shows where it is the gap in legislation. And I think there it's very interesting, and I find very important to find out that might be a big difference between what victims want and what the public interest is. Because I find, like, you know, I need to be talking to my clients about, you know, the chances of winning this is very low. So do you really want to engage in this or not? We can't promise you compensation. It's, you know, So that is something we also faced very much in the KIK case, and where we then also decided, because parallel to the civil litigation we pursued, there was the route of negotiations with the ILO under the facilitation of the International Labour Organization on out-of-court settlement that would cover all the workers as opposed to only the 4 claimants that would bring the civil claim. And we, after long discussions, we decided that we will align the strategy of the legal case so that we are not asking for damages that could be kind of covered under the ILO framework. That was loss of income and medical costs, but we limited the legal claim on pain and suffering claims, which was not necessarily the best, from the pure legal strategy, not the best strategy, because you would not give up a certain amount of damages you would normally ask. But we felt there, because we could not promise to the claimants anything, we felt like that is the way to be fair to them so that they still could get money under the ILO, which, and then also in the end really worked out, because the court case did have a good impact, or did pressure all the parties involved in the ILO negotiations very much, so that they would, I think the case was important of pushing the ILO negotiations, which then led to compensating all of the workers. No, so I would say we lost this, but it's somehow, and if you see it in more of a strategy, I felt like we did manage to handle the strategy between the different actors quite well, and so that I would say the case was in the end also a success, especially also for the victims. No, so.
Thanks, Miriam. Some difficult dilemmas to navigate there.
Yeah.
Dan.
Yes, I see our time is almost up, so I've just got 3 quick points. What are the key factors we look at in determining whether to take a case? I would say 2 things. Firstly, what is the factual nature of the case? Is the harm serious? Is it long-standing? Is it systemic? I'd really echo Miriam's comments that we really want to be taking serious environmental and human rights cases to the courts here. We don't want to be putting forward cases which are could be perceived as relatively trivial or common by any stretch of the imagination. So that's critical. It's also more likely that if it's been a systemic issue that's been in the public domain over a prolonged period of time, that it's much more likely the parent company will have become involved or intervened in it in some way, and that in turn makes it easier to prove the parent company case. Secondly, again, reflecting some of the comments that have been made, we need to be able to, as civil lawyers, we need to be able to prove a loss. The victim, the claimant who's bringing the case, needs to prove that they have suffered loss and damage. That can be reasonably straightforward with personal injury cases in human rights claims, but when you're talking about environmental cases, it can be much more complicated. You have to prove that the environmental damage has caused a specific loss in terms of livelihoods, and that can require sometimes quite complex expert evidence. We did one case in Nigeria. I think we had 11 different expert disciplines in that case to prove the nature of the loss against Shell. I would say lastly this, in terms of the interest of the victims as opposed to the interest of the wider public. We're not in the position of Sherpa or ECCHR. I mean, we are lawyers and our duty is to our clients. So there's no debate there for us. We have to always act in the best interest of our clients. And if our clients want to settle a case because they feel that it's their best chance of securing damages, which can mean an absolutely huge amount to them in the context of their living, then we have a duty to accept that, as much as we may want to fight a case because of the wider public interest. But happily, we have enough quite stubborn, bloody-minded corporations out there who fight come what may, which has allowed us to develop the case law to what it is today. So I think we should thank them for that.
Thanks, Dan. I'm afraid we're kind of rapidly running out of time for this webinar. Just one question. I mean, a number of questions have further questions have been asked, but I think time for just one, which is a question to all of you, which is, you know, the impression is that there are very few firms or organizations that are doing this type of work. And in Europe, there are not many more than are represented by the people who are here today who are doing this work. Why is that? Maybe we can start with Miriam this time.
Yeah, difficult question. Well, I mean, I think...
I haven't got much time to answer it either.
Okay. I think those cases are just complex, no? You need a lot of knowledge and they're difficult to do. So I think if you are a law firm wanting to make a living, then that's not the kind of case, at least in Germany, you want to take. And if you're an NGO, I mean, you know, it's, again, it does require a lot of work, a lot of research and a lot of effort. So I think, you know, I think that may be easier from an NGO perspective. You could also engage in advocacy work, which might be then easier, no? So, yeah, I guess that's my hint.
You were muted, Richard.
Not only was I muted, I disappeared off the screen, but I'm back. Sandra, yeah.
Good question. I would add to what Miriam said, actually, also maybe, well, I don't see the difference between, I mean, separation between advocacy and litigation, because at Sherpa, I mean, litigation comes and fuel our advocacy. And it's also because you have your hands, you know, in the file, that you are more able to expose the inadequacy of the legal framework. So I really encourage to have this kind of double approach. No, I would say, yeah, definitely the complexity, the long-term also strategy, the cost, the expertise, the SLAP, you know, the strategic litigation against public participation, because then it could cost you or the victim you represent, you know, a lot of money, also, you know, pressure. We were under 6 slap from Vinci for having exposed what they were doing in Qatar. So if you are not specialized, you know, you could be really intimidated by this kind of strategy. And this is why it's developed also by corporation, and it's more and more aggressive. It's also, they are usually asking a lot of money. So that's why also lawyers, but investigative journalists are, you know, tend to be much more cautious on that. But maybe I'm hopeful that also, you know, now with maybe the pandemic and climate crisis, you know, people will come and, I mean, towards more, you know, work that gives more sense to humanity and to the earth, rather than just earning money, because obviously you have much more money when you are in a law firm working for a corporation than when you are defending human rights. So maybe, you know, that will shift, hopefully.
Great. Thanks, Sandra. Hannah.
Well, not that much to add, really. I was going to say, like Sandra, obviously economically it's much more interesting to be on the other side. I think all the complications that have been mentioned already show us how much of a problem access to justice in these cases really still is. I mean, it's not just the access to justice problems through the jurisdictional problems and so forth. It's also because of these complications, very difficult to find proper organizations, law firms, specialized people who are taking up these cases. And I'm hopeful too. I think we see a movement wherein more and more of these cases and also more and more of these types of organizations are arising. In the Netherlands, there's definitely more attention for strategic litigation and public interest cases. So let's hope that is going in the right direction.
I think there are some people who've joined us who are from the other side, and to those people I can say to you, it's much more rewarding to be on our side, I can assure you. Dan?
I think that's a great note to end on, Richard. I mean, I think all I would say is I would echo what everyone else has said. I mean, there are two reasons, I think, principally why there are so few actors in this space. One is this is all actually comparatively very novel in terms of legal history. We're all actually breaking reasonably new ground, although you're quite long in the tooth in all this comparatively. These cases have only really been considered viable in recent legal history. And secondly, it's the risk appetite that you need to bring these cases. I mean, these cases are extraordinarily risky for a whole range of reasons. And I think it takes a certain type of personality that's willing to take on these cases. And at the moment, there aren't many around. But I predict it will grow. I think perhaps if this seminar is held again in 5 years' time, you may have double the amount of potential participants.
Thank you, Dan, and thank you to all of the speakers for your presentations. And I think we've had a stimulating discussion. We could have gone on. I know all of you could have gone on endlessly if I'd let you, but I'm afraid we've got to bring it to a close now. I should also thank everyone who's joined us on the webinar. I gather there are several hundred people who've joined, and I hope you've all found it worthwhile. So maybe we'll see you at the next event, but bye for now. Thanks.
Thank you.